afternoon, everybody. This is Victoria Lancey from the Michigan Center for Rural Health, and I would just like to begin today to be mindful of everybody's time, and I will be helping facilitate this Grand Rounds program. I would like to welcome again everybody to today's legal Grand Round on the HIPAA update, which is brought to you by Hallwender, Killian, Heath, and Lyman, and Michigan Center for Rural Health. Before we begin, just a couple of reminders. If you're logged into the webinar portion and have computer speakers, you can listen to the audio through them. If you are only listening to the audio through the audio number provided, handouts are located on our website, and I also emailed them out to you. Our website is www.mcrh.msu.edu. Click on the education link across to your top and scroll down, find today's date, and there you will find the presentation along with an evaluation link. Please fill out the evaluation link. It helps us provide this education for you. The evaluation, please complete this within 2 weeks or by September 28th. If you to ask a question during the program, please type it into the chat box so you don't forget it, and the presenter can address it during the Q&A. And also, I will be unmuting all the lines at the end of the presentation, and then you can also ask it that way as well. Our speaker today indicates no conflict of interest, and the planning committee did not have any conflicts. With that, there's no commercial support for this program, and I am pleased to introduce our speaker, Elizabeth Callahan Morris, who is an attorney at the law firm of Hallwender, Killian, Heath, and Lyman. Go ahead, Elizabeth.
Hi, everyone. I'm pleased to be able to give you a HIPAA update today, and Victoria mentioned she distributed the slides and some handouts. I will do my best to toggle between those as we go through the materials. I think the best way to start out today is to look at the cases that the OCR is making a priority. We've had 9 enforcement actions this calendar year, and we're only into September, so I would expect that we're going to see a handful more by the end of the calendar year. To get started, in terms of lessons learned, one of the cases I wanted to share with you was back in January. The first case of the year was Presence Health. This was an enforcement action based on the lack of timely notification for a breach. The underlying breach was the loss of paper-based operating room schedules that went missing from one of the Presence surgery centers. There were 836 individuals affected by this breach. The OCR reports that Presence Health went beyond the 60-day deadline to notify, and the OCR was notified 101 days after the breach was discovered. Individual notice went out 104 days, and the notice to the media was 106 days after the discovery of the breach. The deadline is 60 days at the longest, but they can impose a shorter deadline if they think the covered entity could have issued the notification in less than 60 days. We have not seen an enforcement action of an entity notifying within 60 days, but the OCR disagreeing and saying you could have done it in 30 or 45 days. We haven't seen that yet. This is the first time we've seen it, and it was a fairly clear-cut one for the OCR because it was, again, beyond the 60 days. The other lesson learned from this case was not only was this one particular breach significantly late, over 40 days late, but when they went in to investigate this case, they found that this organization had issued other late breach notices in 2015 and in 2016. The underlying breach at hand was based in 2014. And so from the OCR's perspective, they saw this as a pattern of untimely breach notifications. So lesson learned there is timely notification. The second case that was also announced in January was a health insurance plan in Puerto Rico, and this was a large settlement amount. It was $2.2 million. They had a USB drive that was stolen from its IT department. And the real problem here was that when the OCR came in to investigate this breach, they found that MapFree, the insurance company, had failed to conduct a risk analysis, and they had failed to deploy encryption. The real that was a problem number one, but the real problem I think that the OCR saw was that when the health insurance company reported the breach and informed OCR that they were taking certain corrective action items like encryption, doing a full risk analysis, implementing risk management plans, and other corrective measures, they didn't do so. And I think that's really what caught the OCR's attention and why this was a particularly large settlement amount. For the third case that we saw this year, this was in February, Children's Medical Center of Dallas actually imposed a civil monetary penalty of $3.2 million. And this is important because, and noteworthy because this was not a settlement. They actually went and imposed an actual penalty. This is the only imposition of a civil monetary penalty that we've seen. All the other cases, there have been about 30 so far or so. Most of them have been settled. The underlying breach in this case was the loss of an unencrypted, non-password protected BlackBerry device at the Dallas-Fort Worth airport that affected about 3,800 individuals. Later, a few years later, they had the theft of an unencrypted laptop that affected about 2,500 individuals. And here again, even though OCR went in to investigate these particular breaches, what they found, the failures that they found, is what ultimately made the decision, or had OCR base their decision to do an enforcement action. And primarily it was because they had the knowledge that this was a risk out there, and they didn't take action quickly enough. We had the first breach that they had with the BlackBerry was in 2010. The laptop was stolen in 2013, and OCR just thought far too much time went by and there wasn't corrective action, and they had another breach. And so I think that's, again, a big reason why this was a large and important case to the OCR. An even larger case was the $5.5 million case. This is a South Florida Memorial Health System. And in this case, it's interesting because we have seen this before. When an organization has a terminated employee, but there's been a failure to take care of the login credentials and to terminate the login credentials. In this case, it was an affiliated physician office that had an employee that was terminated, but continued to access the hospital's EMR on a daily basis for an entire year. And the failures that the OCR found was that there was the failure to terminate the credentials, and there was a failure to review audit logs on a regular basis. And so this was a large breach, the largest one we've seen to date. Going on to the later set of enforcement actions and for lessons learned, this one may hit a little bit closer to home because this is a federally qualified health center, and it was called Metro Community Provider Network. This was a $400,000 settlement. And there was a phishing incident, and a hacker accessed employee emails accounts and were able to access 3,200 patients' EPHI. The OCR found that the MCPN, the federally qualified health center, took appropriate action for the phishing incident, but like some of the other cases we've seen, what led them to conduct an enforcement action was that MCPN had failed to do a risk analysis. And that was really the trigger, not so much the hack, but it was the failure to do that risk analysis. The other one that may hit fairly close to home is the business associate agreement case. This was the $31,000 settlement, and this was for the Center for Children's Digestive Health. in Illinois. Unfortunately, they got tied up into an investigation of one of their business associates. So it was the breach and the investigation was unrelated to the provider, but Filefax, a record storage company for the center, was being investigated, and they followed the money, so to speak, and saw that the center was a customer of Filefax, but neither party could produce a business associate agreement between the two parties. And so I bring this up, and we'll talk about business associate agreements more. We're seeing this as a focus item of the government. Earlier in 2016, you may have heard of the case where there was a parent organization and a subsidiary in Massachusetts where there was not a business associate agreement, and the organization had failed to understand that a parent and a subsidiary could have a business associate relationship, triggering the requirement to have a BAA. So this is another reminder. There's also a case that was prosecuted by the Connecticut Attorney General for a large health system in Hartford that did not have a business associate agreement with the vendor that had a data breach. And so they were both on the hook for the state enforcement action. Going on to another case, the $2.5 million case. This was interesting because it was a different type of entity. This was the remote monitoring company, and they are called CardioNet. They had a laptop that was stolen from a parked vehicle outside of that employee's home, and that affected 1,400 individuals. And this really focused on policies and procedures. When OCR went in to do the investigation, they found that they had draft security policies and procedures, but they were not finalized, and they weren't implemented. And in particular, they noted that the mobile device policy was not finalized and it was not implemented. So the lesson learned from this case is to look at your policies and procedures, not only ensuring that they're up to date, but once they are changed or updated or supplemented, that they be finalized, formalized, and also implemented through operations and through training. We've got two more cases to talk about this year. The Memorial Hermann Health System in Texas settled a case for $2.4 million. This was, to me, a very interesting case, just because I'm seeing a lot of questions with regard to media inquiries. And the underlying facts of this case was a patient allegedly presented a fraudulent ID to office staff seeking care under somebody else's identification. The staff alerted the authorities and the police, and the patient was arrested. The OCR did not have any problem with the police being alerted of this crime on the premises. But what upset the OCR was there was a press release that the organization published about the incident, and senior management, they found, had added the patient's name to the press release, and that was a violation of HIPAA. And then the organization failed to timely sanction the workforce members who added the patient's name to the press release. I think one reason why they took this particular case that affected one person, one patient, but this is the third time we've seen an enforcement action relating to disclosures to the media. You might remember the Shasta case, the California hospital case, where a patient was complaining very publicly through the media about care that she received at the hospital, and the hospital, in its own defense, put out information to the media in response to the complaint, which involved disclosing health information about the patient. That was a large settlement a few years ago. The other one that was a little bit different was in New York, where there was the ER TV show, and there was filming of patients who were in distress, and one actually passed away, and there was a failure to get an authorization. So those are three different examples of disclosures to the media where the OCR is really taking note and taking enforcement actions. And so when you're dealing with the media, please keep those cases in mind so that your PR people, your senior management pause before responding to the media so that you privacy officers or legal counsel who are involved can ensure that no protected health information is being revealed to the media. That would be a violation of HIPAA. The last case and the most recent case is also, I think, rather interesting because I get this scenario from time to time from clients. This was a case, St. Luke's Roosevelt Hospital Center, and there was a mistake that was made. A patient had asked for his health information to be sent to his own PO box, and instead an employee made the error of faxing the PHI to this patient's employer, and unfortunately this protected health information included particularly sensitive health information such as HIV status, STD status, medication list, sexual orientation, and mental health information, as well as a history of physical abuse. And so this was very sensitive information. It was a big error, and my attention was drawn to it because I have handled cases where information has been faxed to employers. This isn't the only time that it's happened. So again, the lesson learned is to use extreme care, certainly for faxing, but for any disclosures of information where you're relying on an email address or a fax number or even a mailing address for staff to double check that they have got the right contact information and that the information is going to the correct place. So that's my quick summary of the 9 enforcement actions this year, which I think all of them are quite interesting. All of them give us lessons learned. The next topic for our HIPAA update is looking at what's going on with the HIPAA audits. It's been a little bit quiet in terms of what the OCR is putting out about it, but they're working hard in the background as we understand it. Last year they had 167 desk audits for covered entities, and they picked certain aspects of the privacy rule, the security rule, and the breach notification rule. The privacy rule focused on access, patient right to access or to obtain a copy of their medical record, and the issuance of the notice of privacy practices. The security rule focus was on whether the entity conducted a risk analysis and was implementing a risk management plan. And the breach notification rule focused on if the content of the notification was complete and if the timing of the notice was within that 60 days. And as we talk about the next, I've got a slide on kind of frequently asked questions and some guidance that the OCR has put out, looking at those lists and then also looking at some of the lessons learned from our enforcement actions. We see a real distinct pattern with what the audit topics covered, and this is just really their focus area. But first, a little bit more on the audits. They expanded the audits to business associates, and they selected 33 business associates to audit. They're about to do on-site audits. Some of those have already started, the covered entities and business associates. In total, they're going to add on a few more. They said at the end of the day, it'll be between 200, which would be the 167 plus the 33, but they may add on another 50 entities to do audits on site. We are waiting to hear how those go. What's interesting so far that we do know is that they're being pretty tough. The findings are fairly tough. I do have an example in the handouts of how they're grading, and I'm going to try to flip to that now. And let's see if I can get that view a little bit easier to read. I'm just going to turn it clockwise. what they've done for those 167 covered entities is that they each individually have received a draft report of how they did during the audit, and those covered entities had the opportunity to respond. You couldn't submit additional information, but that you could respond to some of the findings. And let's see, I'm going to scroll down a little bit more. There's going to be, yes.
Can't see that. Sorry.
Oh, I've got it. Oh, I've got it shared on my screen. If
we just have your PowerPoint still. Sorry.
You still have the PowerPoint? I'm sorry. I've got it on share, and I'm not sure how to correct that. But I'll describe it to you. And also, I know it was emailed, and it's posted on the Michigan Center for Rural Health. I'm sorry, Victoria?
Which one was it?
This is the PDF. That's the OCR Audit Draft Report document. And so what I'm showing on the screen now, and you can reference later, is the legend. It's ranked from 1 to 5. For each standard measured during the audit, 1 would be the highest and 5 would be the lowest. And for the clients that we've worked with who were part of this audit, they're getting a lot of 3s. It's pretty hard to get a 1 or a 2. And so the standards are pretty strict. And we're seeing a lot of 3s and 4s. So I wanted to bring that to your attention as well. On the third page of that PDF, once you are able to review it, it's an example of the very specific findings that the OCR auditor has. The example that I'm providing was for a notice of privacy practices. I do want to bring the NPPs to your attention as a reminder. I know we've had those around since 2003, and everybody's been distributing them for the most part. But what we have been noticing is that a lot of organizations still have forgotten to post those on their website. They've forgotten to update them for high tech. And they have forgotten to put the date, the effective date, on that notice of privacy practices. We've also been finding some clients, as we've been doing some assessments for resources efficiency, which I completely respect and support, but not in the case of notice of privacy practices. We've had a client where they wanted to distribute all of their printed copies of the old version, and their plan was when those ran out, they would start distributing their new version. But our recommendation is not to do that. Go ahead, shred, discard your old versions. I know it's a waste of paper, but start distributing your updated notice of privacy practices. Make sure that if you are reconfiguring lobbies, if you're renovating, you're doing additions, and you take down the posted notice, make sure that the new one gets posted back up once renovations are completed. We've just seen that frequently, that the new space build-outs are not getting the notice of privacy practices. And so I'm going to go back to the slides, which I think you're looking at already. And I just wanted to let you know, in terms of a resource, OCR still has their protocol posted to their website, which you can access. They did update that finally for the high tech rule. And so if you go to that audit protocol, it's up to date. That's what the OCR is using. That's what I personally use when I do compliance assessments for clients as well. Going on to OCR guidance. They've put out a lot of information. This is just 4 of what I think are the highlights recently. This privacy rule waiver for the Hurricane Harvey and Irma doesn't affect us here in Michigan directly, but I think it's important to be aware of in case there is an emergency situation in our state. And I also think it's important to know that this is happening in other parts of the country, because if you ever have to interface with a provider that is in an emergency zone where there's been a privacy rule waiver, you can be aware of what they're experiencing and what differences they may be undergoing. The what a privacy rule waiver means is when there's been a declared emergency by the Secretary of Health and Human Services, and there's been, in addition to that, there's been a waiver of the HIPAA privacy rule. Not the entire HIPAA privacy rule, but five subparts of the privacy rule. The waivers are that you don't have to obtain the patient's agreement when you're communicating with friends and family. So you're relieved of that burden. You're relieved of the burden of honoring requests of patients who want to opt out of a facility directory. So that's not a burden or requirement while there's this declared emergency. You're not required to distribute notice of privacy practices, and you're not obligated to accept requests from patients for privacy restrictions and confidential communications. And so all the other privacy rule requirements remain in place, and all of the HIPAA security rule requirements remain in place. But this was a timely issue, and a timely guidance came out, so I thought it was important for us to mention it today. What I encourage you to spend the bulk of your time on, and the real takeaway of today's webinar, is going to the OCR website and work through all the information that they've published on the patient right to access. They've got a new set of materials, and they're titling with the catchphrase, "Get it, check it, and use it." And this is a continuation of the OCR's effort to encourage individuals to get access to their health information, make access requests, which is to get it from you. Check it means for patients to review it to make sure it's accurate, and if not, to make amendment requests to the covered entities, to the providers, which then in turn you would have to respond to, and then using it, and so that there's dialogue between patients and providers about their medical health information. There is a lot of information on the website. There is 3 cases that they've put out, 3 personas. They're fictional, but based on real cases where they've tracked 3 individuals and the difficulty that they've had in obtaining copies of their health information. I would go through that. That's their patient experience. They have a video, several videos to watch. I encourage you to do that, watch those, decide who in your organization would benefit from these videos and their contents. Most likely your health information management departments, some of your front desk personnel as well. And then I'm also bringing this up again because we're seeing a lot of questions about access. And I'm going to try to share my screen again. I don't know if it'll work, but the other handout that I want to bring up to you is the copy fees. There has been a change, and I think much of the industry is behind on the change to the copy fees. Many people are still following the Michigan Medical Records Access Act per page fee, which is not available to covered entities under HIPAA who have EMRs. If you are a paper medical record only provider and you're providing that paper copy, or if you download it into a PDF on a CD-ROM, you can charge a per page fee, but you can only charge the Michigan per page fee if that actually reflects your average labor costs. So the Michigan law is not to be followed. If you've got a patient request, you've got to follow the HIPAA schedule, which allows you to calculate your average labor costs, and then you can implement that as part of your policy or your fee schedule for copies. If you want, you can default to a $6.50 flat rate if you are making an electronic copy of an EMR. So I do, in terms of this, the bigger takeaway for access rights, I encourage everybody to go back, look at your copy fee schedule, make sure that you've updated it to comply with the guidance that OCR has put out, they are going to be checking that, and that's part of their materials that they're putting out to patients. So you know that they're telling patients they can't be charged a per page fee unless it's a paper medical record. The other group that has caught on before the patients are the lawyers. The lawyers have caught on to this, and the confusion that we're seeing is that our clients receive letters from attorneys, and they're asking for a copy of their client's medical record. The attachment is one of two things. One, it is simply an authorization from a patient, which, in my opinion, does not trigger the HIPAA copy fee limits. That is when you can follow the Michigan per page fee limit. The second type of document, in the alternative, the lawyers that have caught on to this, what they are attaching is a statement kind of blended with an authorization that really essentially is a request for a copy of their medical record to be sent to their attorney. Now, it may seem like splitting hairs, and I agree it is, but it's a hair that really has to be split, is if the patient is asking for a copy of their medical record, which means they're accessing or they're exercising their right to access, and they're directing to whom that record should be delivered, if not to their home address and to their attorney's address or somebody else, that is an access request under HIPAA. The difference is that if they're simply authorizing or permitting you to do that, that is not an exercise of a right under HIPAA, and you're not obligated, number one, to reply to the request, and number two, you're not obligated to be limited to the HIPAA copy fee limits. So this is, again, if you're using an outside vendor and or you're coordinating with your health information management department to make sure that everybody is on the same page as to how to process the request, how to determine if it's a third-party request or if it is a patient access rights request. And then secondly, that'll drive you to be able to impose the correct medical record copy fee. There are a group of, and this is in Michigan, a group of attorneys out there that are submitting complaints to the OCR when the hospitals are replying, and they are not intending to overcharge and they're not intending to violate HIPAA, but they're really doing it inadvertently and mistakenly, but they're turning into Office for Civil Rights HIPAA investigations and complaints. I'm going to toggle back to my slides here. The HIPAA breach reporting tool, the OCR has updated their wall of shame, as it's called, of breaches that have affected 500 or more patients. And it's easier to sort and search and look for examples, see how many times your organization has been up there or not at all. There's one caution that I give when looking at the breach reporting tool. You may be scrolling through it and looking at different examples of reported breaches. In some cases, those breaches were not required to be reported. And so if you see an example such as an employee emailed PHI and they didn't encrypt the email, and that organization decided that was a reportable breach and they reported it to the OCR is going to post it as a reported breach, even though, unless there was in some sort of intervening actor or there was a wrong recipient. In my opinion, unencrypted emails are violations of the security rule and the privacy rule because they're unsecured, but they are not reportable breaches in and of themselves. It's a failure to safeguard and you haven't met the standards, but it's not a reportable breach unless it was intercepted or it went to the wrong recipient. So the caution is going through this tool, if you see examples of incidences that you've experienced but didn't report them, don't immediately panic and think that you should have reported it. Please go back and there's a chance you should have, but don't automatically presume that you were in error and did not report that. If you're unsure, reach out to your counsel. You can reach out to me, and we can help walk through it. The last one, and it's fairly important because we're seeing such a large increase of different types of cyber threats and ransomware campaigns. The OCR put out guidance that they presume automatically that any ransomware event is a reportable breach. And to the most part, or to the most extent, I would agree with that, even prior to the guidance that they put out. But the real takeaway, there's definitely debate in the legal industry as to whether that was a good guidance and solid ground that the OCR is on. But my takeaway from it that I want to share with all of you is that it just even further puts the burden on the covered entity to demonstrate that even though there was a ransomware event, going through a risk assessment, that if it can be demonstrated typically through forensics, which is not cheap, but typically well worth it, if you can demonstrate that there was a low probability of compromise to that PHI, meaning the hacker didn't actually access any PHI, didn't actually copy that PHI, didn't exfiltrate the PHI, then you can really create quite a solid risk assessment analysis and conclusion that there was a low probability of compromise and as such not a reportable event. But because we're seeing so many of these, I wanted to bring this to the attention, especially and also because it's being debated. Some other questions I get about ransomware, and we've had some clients experience this in Michigan and in other states, is we're asked, is it illegal to pay the hackers? Is it illegal to pay the ransom? That's debatable. We have not seen any type of enforcement action against a person or a company who's actually paid the ransom. And my advice to clients have been, if you don't have backup data, which you should, but if you don't, and you cannot operate and safely treat patients without that data, and if it's a financially affordable ransom, in those limited instances, I encourage the client to pay the ransom if that's their decision. But if they have a backup, then or they can operate with a legacy system or in some other fashion, I encourage them not to pay the ransom. Unplug those computers, report it to the appropriate authorities, and continue to operate without paying the ransom. But each situation is very different because it depends on the type of ransom, the type of encryption, the type of information, the type of information system, the amount of the ransom, which also is also paid typically with Bitcoin. We've helped clients even set up Bitcoin accounts if, to take care of these situations. Every situation is different, and so I just highly recommend having an action plan in place ahead of time. So if you are hit, you know what to do and you know what your options are. So in terms of the rest of the materials today, we'll go down one more here. Let's see. I've listed here, and we've talked about some of them already, the client frequently asked questions that I get. We've talked a good bit about access requests and copy fees. I'd be happy to answer more questions about those. I, on a regular basis, get questions about law enforcement officer requests for health information. They typically, maybe 50-50, I would say, but maybe about half the time those are permissible disclosures and half the time they are not. And often your staff is going to be somewhat intimidated by law enforcement, or they're going to be extremely inclined and without hesitation want to disclose information to law enforcement. Again, this is a training reminder to go back to your the people on the front lines there and make sure that they've got resources available to them, either the privacy officer, the security officer, legal counsel, or senior management, to have those requests vetted. Very, very rarely is it a life and death situation when there's a law enforcement request. In life and death situations, I err on the side of life and safety, and we can deal with the privacy violation a lot easier than a bad patient outcome or a patient death or somebody else's death or injury. But for the vast majority of law enforcement requests, they can wait. You have the obligation to be thoughtful, to ensure that the request is appropriately reviewed and the right information is provided or the right response is given to law enforcement. As a general rule, I advise my clients to be very cooperative, very polite, and very responsive to law enforcement. You can do all those things and comply with HIPAA and protect your patient's privacy at the same time. They are not mutually exclusive. Oftentimes, I will tell a law enforcement officer, we are making copies of the requested information. As soon as we get approval for it, it'll be ready to be given to you right away. And so that they know that you're not trying to interfere, you're not trying to be uncooperative, you're getting the information compiled simultaneous with getting approval to release it. And then if it ends up that you can't release it, you have it ready, you tell them they need a court order. And so I think going through your policy and disclosures to law enforcement, doing training, is a great idea, because I'm quite sure most, if not all of you, are getting these types of requests on a somewhat regular basis. I do get a number of questions about marketing communications. A real pretty easy one is, yes, you are allowed to use your patient list to send letters to your patients about your services that you provide. Those are permissible communications. They're not considered marketing communications in violation of the rule. You don't need an authorization. The one caveat is that you cannot receive payment from a third party to make those communications. There's a lot of other nuances out there as those facts change, but that's a fairly straightforward marketing type communication that's allowed. We often, onto the next topic, still get a lot of questions about communications with friends and family. We get a lot of complaints about those. Patients are complaining that information was impermissibly disclosed by a nurse or a physician when they had a friend or family member in the room. There's a very handy, easy to use, brief guidance that the OCR has put out. It's on their website. One is written from the perspective of the provider, and one is written from the perspective of a consumer or patient. I encourage you to be familiar with both of them. They are consistent. Again, using that as a HIPAA refresher. And on this point, I think for access requests, law enforcement, marketing, and friends and family, my recommendation for if you do annual HIPAA training is not required. It is a best practice. I think it's more helpful, instead of doing the same training every year, is to pull out 1, 2, 3, or 4 of these topics and use that as your refresher. Drill down onto some of these the special areas of privacy and security. Of course, for your new employees, you got to do the full HIPAA training. But I think for refresher training, it's more meaningful and more effective to focus in on some of these FAQs, as I call them. Breach risk assessments. We're dealing with wrongful uses and disclosures all the time and different security incidents. You've got to have a written breach risk assessment. If you're not going to report it, it's got to be documented. It's got to be done at the time the breach has occurred and you're analyzing it. As part of the resources and handouts that I sent a sample breach risk assessment. This follows the guidance that, not the guidance, the actual privacy breach notification rule that the OCR put out. It follows the 4 factors that have to be considered. You can consider more of those. There's other samples and templates out there floating around. Sometimes we use a point system. The one I sent to you for this group, this webinar, is more of a narrative summary of each and consideration of each of the factors, and you can rank them as low, medium, or high. Again, low, medium, high is not from the the OCR, from the breach notification rule. That's just a terminology that I and others use for risk assessments. So you can use that template if you want. You can use your own template. The only reminder here is that make sure you're not using an old risk assessment under the old standard, which was significant risk of harm. That's not the standard anymore, so don't use that template risk assessment. Use any new one, like the one I sent to you, that talks about the probability of compromise. That's the standard. The next is topic I have is I still get tons of questions about, is this vendor or this entity a business associate or not? Make sure you're doing that analysis. Make sure you're getting your business associate agreements signed, and make sure you're getting them in a log. This has been the recommendation long-standing that we've given clients, but it's just a continuing need that we've been observing. So keep that really as a top priority for your HIPAA compliance program. Social media, we're getting more and more questions about social media. These are tough questions to answer. Certainly never use social media to disclose PHI about a patient when you're responding to a complaint on social media. Our recommendation is simply, please reach out to our patient relations department. Or if the patient has identified themselves, you can contact them directly with the contact information you have on file. And so you can communicate with them one-on-one. You want to strongly avoid any public disclosure of health information through social media. A tougher question that I'm sort of wrangling with now for a client is when they have a patient on their patient's personal Facebook page, Facebook, or share or like or comment on the provider in a very complimentary way. They want to be able to share or like that comment. And that's a tricky, I think that's a tricky situation because the implication is that you're confirming that that patient was a patient of yours, and you're confirming any health information that the patient may have disclosed. But it also seems to be fairly low risk from just a common sense that if the patient put it out there, why can't we just like their post? What's wrong with that? Why would that be a violation? And so we're helping clients kind of walk their way through those risks. Some clients are much more risk adverse, and some are willing to take that risk, and they're trying to mitigate it with adding a provision to the Notice of Privacy Practices, for example. The last FAQ that I'll mention, and then we can go into questions, is the application of the Michigan Mental Health Code and the application of the federal rules that we refer to as Part 2. And those are additional privacy obligations that are imposed on substance abuse providers, substance abuse treatment providers. And then, especially in the context of those changing rules, the Michigan Mental Health Code has been amended, and the SAMHSA, the federal agency in charge of the Part 2 regs, have put out guidance, changing guidance on authorizations in the context of HIEs. And it's difficult because we've got HIEs and we've got integrated EMRs. And so we're getting a lot of questions there. So the reminder and takeaway for this group is make sure your organization has a good understanding if and to the extent the mental health code applies, and if and to the extent the Part 2 substance abuse treatment privacy regulations apply, and how are you dealing with those in light of your EMR and your HIEs that you may participate in. And that's my update for this group today on HIPAA.
Okay. We'll now open the lines for questions and comments, or you can feel free to use the chat box feature. So I will unmute all the lines. So all of our lines are now unmuted, so feel free to ask your question to our presenter or use the group chat.
I do have one question.
Go ahead.
So is this presentation recorded to where we can share it with our staff?
Yep, I'll have it recorded and then I'll have it posted on our website, either later today or tomorrow morning.
Okay, that'd be great. Thank you.
Yep.
Very informative.
Do we have any other questions for our presenter? Questions or comments for our presenter? If you can't think of any questions now, you can always indicate them on your evaluation, or you can email them directly to me, or you can email, it looks like Elizabeth has left us with her email as well, so you could always email them directly to Elizabeth that way as well, if you need a little bit for the information to sink in. We'll go ahead and sign up, I guess, since nobody has any questions or comments. Thank you, everybody, for joining us, and have a great day.